So I want to welcome Eric Romano to the Legally Exhausted podcast. Eric, how you doing today?
Good, doing just fine. Thanks for having me.
Thanks. We're here on a Sunday, grinding out. We just had some new issues come up in the Florida Legislature about tort reform, and we wanted to bring you in. You're an expert. You're a former FJA president, really smart guy, smarter than me, and wanted to talk to you about some stuff. But before we get into all that, can you talk to us about you, where you grew up, where you went to school, a little bit about why you became a lawyer?
Yeah, sure. Well, first of all, thanks for having me. It's good to see you and good to be here. I grew up right here in Palm Beach County. So not born here, but more or less raised here, kindergarten all the way through 12th grade. First Sacred Heart Elementary School in Lake Worth, and then on to Cardinal Newman High School in West Palm Beach.
Cool.
Left long enough to go to do my undergrad at Florida State University. Got my degree in business management there, and then on to law school at Stetson University over in St. Petersburg.
Tell me a little bit about your practice. What's one of your cases that just makes your heart, something that's one of your cases that just really affected you in your life? Doesn't have to be the biggest case you've had, but just a case that really touched your heart over the years that you've been practicing.
So many of them come to mind. I'll tell you the one that immediately comes to mind. It was relatively recent, and this was a case we actually handled in Utah. Wow. This was a 14-year-old boy who was a freshman in high school out there and was in his freshman theater class. His drama teacher asked him to get in a man lift and go 30 feet up to the ceiling to change some light bulbs in the school auditorium.
What's a man lift? Like the thing with the arm, like a crane that you stand in?
Like a scissor lift.
Okay.
Like a one-man scissor lift.
Okay, gotcha.
So you push a button and it raises you up 30 feet.
Okay.
So this is a high school student with no training, no safety harness, nothing. He's 30 feet up, and the instructor tells a couple other students, go ahead and just push the lift across the floor so we can move him over to the next light bulb to change it. Lift falls over. This young man falls 30 feet, lands on the stage, is immediately unconscious, has all kinds of broken bones, orthopedic injuries, skull fracture, and horrible brain injury. Was in the hospital in a coma for about 3 months, and went through years of physical therapy, rehab, cognitive therapy. He is now in his early 20s. Happily, I give you kind of the silver lining. He has gone on, graduated high school, ultimately went to college, is still studying and taking some college courses, but he is profoundly brain injured and will have severe limitations physically and cognitively the rest of his life. He'll need lifelong care and supervision.
Wow.
That case gave us an opportunity to change Utah law. Because at the time the incident happened, Utah law did not recognize a cause of action for a parent's loss of consortium for an injury to a minor child.
Loss of consortium, for our viewers, is the loss of the ability to...
It's essentially the...
I don't know how to describe it.
Yeah, it's a loss or impairment of your relationship with a loved one. So in the case of a parent's loss of consortium, you're a parent, I'm a parent. Nothing hurts a parent more than to see your child in pain, whether mental or physical. Right? The law recognizes that when a child suffers, there's a corresponding injury, usually a mental or emotional injury to the parents. Many states, including Florida, recognize that cause of action.
Okay.
Utah at the time did not. We felt the circumstances of that case provided an opportunity to try to change the law in Utah. So ultimately, we went through the steps in the trial court. Predictably, trial court dismissed that claim because it wasn't recognized at the time, and we were able to take that issue up to the Utah Supreme Court. Utah Supreme Court ultimately issued an opinion essentially saying, we hereby adopt as a cause of action in Utah a parent's loss of consortium when their minor child suffers an injury.
Wow.
So that not only was a case in which we had the opportunity to hold, but by the way, there were punitive damages in that case because of some circumstances leading up to the lift falling over. We were able to hold the wrongdoers accountable, get a recovery for our client and his family that will provide him all of the medical care and supervision he'll need the rest of his life. And we were able to change Utah law in a way that should help countless future families in Utah bring those claims in similar situations.
Was there any sovereign immunity caps in Utah? Sovereign immunity is where the government, you typically can't sue the government, but they allow you to sue the government. And there's, like in Florida, we have caps. They just increased those caps a little bit. Is there any caps like that in Utah?
Good question. That was a private school in that case. So wow. Sovereign immunity did not factor in.
Did not apply. Okay. I can't believe they would even have a student go up. That's what you have handyman at the school for. That's beyond absurd.
It's one of those things. It was just an unbelievable set of circumstances and horrible outcome for this young man and his family. Look, it's a lifetime of suffering for him, but that's an example of what we see every day. And remember earlier when I said, people don't call until they've had a really bad day. That's an example of what we do, why we do it, and why people turn to us for help.
And you know what the viewers need to know is you, the trial lawyers, nobody gets paid on that case until it's paid out. And so this case went all the way up to the appellate court, and I'm sure they had a trial back down below to determine those damages, right? Because it wasn't calculated in the initial outcome.
The case ultimately settled.
Okay.
There was not a trial.
There was not a second trial.
But it settled after several years of litigation.
Okay. Wow. That's incredible. And you guys took it to the Supreme Court in Utah. That's amazing. Wow.
Yeah.
Give me another good one like that, man. That's incredible. I don't have anything like that. You got to tell me another one.
I'll touch on this real quick, though, because you mentioned lawyers handling cases on a contingent fee, right? And earlier you referenced frivolous lawsuits. I've always said, look, the insurance industry, some in the legislature and politicians often want to talk about the need to rein in frivolous lawsuits. Well, the best protection against frivolous lawsuits is the contingent fee. All right. I don't know about you. Okay, if I know that my fee depends on me winning the case, I'm not taking a frivolous case, right? We do a lot of due diligence at the front end, as most lawyers do, to investigate the case and make sure that it's factually and legally sound. Now, does that mean every case is perfect? No. Does that mean there are debatable issues in every case? Of course. Okay, but no lawyer I know is ever going to take a case that they think is frivolous or without merit.
Right, because they want to get paid. They have bills to pay just like anybody else.
Right.
Yeah.
So I'm only taking the good cases that I think have a solid factual and legal basis, because otherwise I'm working for free and throwing money and time and resources at something that may never pan out. This is a little bit different, but it's fresh on my mind because we're dealing with this right now. We have been involved for the last 5 years in the national opioid litigation. So we have been representing about 40 cities and counties around the state of Florida in lawsuits against the opioid manufacturers, distributors, and retailers. And it's with hundreds of law firms around the country. I mean, a big collective national effort. And this is to hold the opioid industry accountable for the opioid epidemic in this country that's touched every community from border to border. And through that litigation, we've been able to help recover billions of dollars for every state, city, and county in the country. That is money coming back into local communities to help fight the opioid epidemic, to implement opioid abatement programs. And with the clients we represent, it's been able to bring a lot of money back to the state of Florida for opioid abatement purposes that will save countless lives in the future. No way to quantify it, but that's just another example of litigation that has used the civil justice system in a productive, valuable way to help save lives and make our community safer.
Yeah, and that opioid litigation, what I found most interesting was local governments saying, hey, we need injury attorneys to help us collect this money. They didn't want to use their local in-house, city attorney to do this. It's way above that pay grade caliber. And you're talking about is it public how much the collective settled for? The collective opioid cases settled for?
Yeah, nationally, it's billions of dollars.
Billions. Wow. And who paid that exactly?
It's a number of defendants, but it's some of the main distributors of opioids, the main manufacturers of opioids. Purdue Pharma is one of the big ones. It's been in the headlines for years. But there are many defendants in each of these lawsuits. All the lawsuits, thousands were filed around the country. They were all consolidated in an MDL in front of Judge Polster in Cleveland, Ohio.
Okay.
And so Judge Polster has done a remarkable job presiding over very complex litigation with a lot of moving parts. And although the litigation is ongoing, many settlements have already been reached. It's bringing money back into local communities all over the country.
Because and the purpose for that isn't just it's not a money grab. It's local communities dealt with increased crime because of the opioid crisis. Not just increased crime, but hospital stays, death-related medical care and all that stuff, increased need for police, all that stuff factored into this, right?
A lot of increased need for first responders, a lot of EMS calls for overdose situations, need for Narcan, naloxone to treat the acute overdoses, ongoing treatment and rehab programs. And, that they didn't budget for that.
Right.
So it's a problem that was kind of dumped on every single community without the resources to fight it. This litigation and the settlements now give every community the resources to help fight it. It's not a complete solution, but it's a lot of money that is going to put in place a lot of really good programs to reduce opioid addiction going forward.
And in the future, I'm assuming these pharmaceutical companies are going to say, before we push out these drugs, let's have training on who should get them, right? These medical doctors were just giving them out at one point. They were just giving them out to anybody, right?
Right.
And so that's awesome work. That's incredible work. Thank you for sharing that.
Yeah. Well, cool. It's again, it's a every time I hear anybody bashing the court system or lawyers and the work we do, it's cases like the two I just mentioned that of course I think about, and I think it's up to us as lawyers to do a better job educating the public and our elected officials about the important work that we can do if the courthouse doors are open for everybody to seek redress.
Right. Awesome. All right, cool. And so tell me, I know you have a long history with the FJA. You told me about that when we first met. You did some volunteer work with your father?
I did. I kind of joke with people that I may be the longest serving member of the Florida Justice Association because I literally have been a member pretty much since birth. So my dad is a trial lawyer. I am happy to be able to practice law with him every day. He is still going strong, going full time, and we get to work together along with him and my brother.
Cool.
But Dad has been an active member of the Florida Justice Association, what then was the Academy of Florida Trial Lawyers. So literally since I was born, I have been going to FJA events. I have been at the board meetings. I have listened to him talk about the important work that FJA does in Tallahassee and around the state. And so as a kid, I would go to these events. I would sometimes sit in on some of the meetings. I would see the important work that they did. And then as I got to high school and college, actually in high school, volunteered and did a lot of work in 1988 on the Amendment 10 campaign, which was a very, very important and significant issue that went on the ballot back at that time. And that really opened my eyes to the important work that FJA does and continues to do. So as I came out of law school, started practicing law, the first organization I joined was then the Academy of Florida Trial Lawyers, and I've been very actively involved in it ever since.
Cool. I know it's going back far to 1988. That's when my wife was born. Do you remember what Amendment 10 was about, roughly?
I do. I sure do. Yeah, so Amendment 10 was a constitutional ballot initiative that was pushed by the medical industry, the insurance industry, the Chamber of Commerce. It would have capped non-economic damages in every single case at $100,000. Regardless of the facts, regardless of the evidence, regardless of how outrageous the defendant's conduct was, would have capped those damages at $100,000.
Could you, for the viewers, give us an example of non-economic damages, what that means?
Sure. So non-economic damages are the intangible damages, the what's often referred to as pain and suffering. The way Florida law describes it, it's mental pain and anguish, physical pain and suffering, inconvenience, loss of capacity for the enjoyment of life. It's those intangible, non-economic damages that people suffer in the wake of a tragedy.
Okay. Awesome. And so Amendment 10 did not pass, I take it?
It did not. No, it was thankfully it did not, because it would have shut out countless families and injured victims in the decades since. But no, the Florida Justice Association worked very, very hard to defeat it. Thankfully, it was defeated. The voters went to the polls, recognized just how unfair and bad that amendment would have been, and it was voted down. You know what I like about the FJA is it seems like they're quietly doing work for Floridians in Tallahassee year after year. For things that, I'm a personal injury lawyer. I never heard of Amendment 10 before I talked to you about it. And they worked behind the scenes to get these things so they don't pass, which I like about them. That's exactly right. And you're right. Most people in Florida don't know that the FJA exists. But to me, the FJA, they are the watchers on the wall in Tallahassee. Watchers on the wall. Yeah. So FJA really is a group of the watchers on the wall in Tallahassee. You're right. They work kind of behind the scenes, protecting every Floridian every day. And frankly, they're the only group in Tallahassee fighting every day to protect injured victims and consumers. And, without FJ and the work that they've been doing now for decades, the courthouse doors would be closed to a lot of people and a lot of families. Right. And, there's often a lot of talk about the importance of various amendments in the Bill of Rights. We hear a lot of people talk about the importance of the First Amendment, the Second Amendment. All right. You don't hear a lot of people talking about the importance of the Seventh Amendment, but they're all equally important. So the Seventh Amendment, the right to trial by jury, right? The legislature every single year being pushed by the insurance industry and corporate elites come to Tallahassee and push for legislation that would turn trial by jury into trial by legislature. And that is, in large part, what FJA fights against. But the big picture, ultimately, is fighting for safer practices to make sure people and companies act more responsibly and safely, that they're held accountable when they don't, and that there are consequences for misconduct. And that's kind of big picture what FJA does every day. And awesome. And do you know one big thing that the average Floridian, the average consumer in Florida could point to and say, the FJA helped back that? That was their backing. Well, I mean, going back to Amendment 10, that's one big thing that most Floridians don't know about. I think most didn't pay much attention to it back in 1988, but that's a prime example of something FJA fought to keep, kind of keeping current law with no caps on damages, which means the average Floridian who is harmed in any way by any defendant or corporation or bad actor has the right to hire an attorney, go to court, hold that wrongdoer accountable, and let a jury of their peers under the Seventh Amendment listen to all of the evidence from both sides and decide what they think is an appropriate result in that case. And had FJA not stepped in, done the work they did in 1988 to defeat that, you'd have a lot of families suffering horrible tragedies over the last 35 or so years that would have been shut out of the courthouse because of that, if that initiative had passed. Okay. And let me bring up medical malpractice, right? They got caps on damages. Do you know when those came out in like 2003? Caps on medical damages? I think they were initially passed by the legislature in 2003. Okay. And it's a $250K cap? It was. Okay. It has since been declared unconstitutional. Okay. Yeah, but Yes. There was kind of a sliding scale. The caps were a little bit different depending on whether the defendant was an individual doctor or a hospital.
Okay. And so I remember, I'm thinking of this tort reform that the legislature is trying to pass now that they put forward, House Bill 837, and I'm going to this case that was big in the news when I was a lot younger. I was born in '84, so it was after 2003, but I was in college and maybe I was in law school, and it was a woman who lost 4 limbs. She had kidney failure. She went to the hospital. The doctor was an idiot, misdiagnosed her, said, "Nah, you're fine." If he would have just given her the appropriate medicine for kidney failure, she would have had all 4 limbs. She was married at the time, 2 kids, and I got to find that case. And basically, she was capped at like $250, lost 4 limbs, couldn't get any more money than that. And that kind of stuff reminds me of what's going on now. On a larger scale, because that was medical malpractice. This is what they're trying to pass now, is for all kinds of car accident claims, all kinds of injury claims. It's not one particular niche. With medical malpractice, tort reform, they say if we don't do something for tort reform, doctors won't practice medicine. They're going to practice defensive medicine. Their insurance premiums will go up. They'll leave the state of Florida and practice elsewhere. Any thoughts on any thoughts on that, on those kind of scenarios where somebody's life is so upheaved after a tragedy, and the most the attorney can get for you is capped because of the legislature?
Right. Well, there's a lot packed in there, but it's what we do, and the civil justice system has a lot of moving parts to it. As I tell everybody, look, I represent victims in personal injury and wrongful death cases. So my clients don't need my help until they've had a really bad day, and in many cases, the worst day of their lives. Mm-hmm. My phone doesn't ring until somebody's suffered a horrible tragedy. Ultimately, the civil justice system, much like the criminal justice system, is designed for holding wrongdoers accountable. Mm-hmm. Right? As a civil trial lawyer, I view myself, much like you view yourself, as a private law enforcement officer, right? We enforce the law. When companies and individuals act negligently or intentionally and cause harm due to their misconduct, then clients turn to us to use the civil justice system to hold those wrongdoers accountable. Mm-hmm. Going back to what we talked about earlier, the beauty of the 7th Amendment is we take average citizens made up of our peers to listen to all of the evidence from both sides, mm-hmm. and reach a determination that they think is a fair and reasonable result based on all the evidence. Mm-hmm. And what happens when you hear about tort reform, it's really tort deform, because most people, when you hear the word reform, you think, that must be a good thing. Okay, tort reform is never a good thing. Mm-hmm. And by the way, I think most Floridians don't know what a tort is. I didn't know what a tort was until I got to law school. Right. A tort is basically just it's a wrongful conduct that harms another. Mm-hmm. All right. And most people don't think about these issues until it happens to them. And even when I meet with legislators, they can look at legislation and say, that sounds like a great idea, until it happens to them or their family. Mm-hmm. And we don't wish that on anybody, because as we said, nobody needs our help and nobody needs the civil justice system, mm-hmm. until something really bad has happened. But when you start restricting people's access to the courts, making it harder for injured victims to hire an attorney, making it harder for them to hold the wrongdoers accountable, then what happens? Okay, you have more unsafe conduct, because you remove the incentives to act safely. Mm-hmm. And if you start capping damages or putting a limit on what an injured party can recover, all you say to the wrongdoers is, the consequences for your misconduct are not as bad. In other words, we're lessening the incentive to encourage people and companies to act safely and reasonably and responsibly.
Okay. All right. Awesome. let's talk a little bit about House Bill 837, which is right now proposed, I think, on Monday or Tuesday. I was in Vegas at a work conference with my wife, and she looks at me, my face goes white. I said, "Oh no, this is awful. This is not awful. Good." Yeah, it is awful. Let's talk about that. That was introduced, by the way, by an insurance defense lawyer down in Miami, and another member of the House that is an attorney but doesn't practice insurance related matters or anything like that. I think it was real estate or something. But we'll talk about how an insurance defense guy gets to propose a bill that only helps the insurance companies. But let's talk about House Bill 837 right now. What is the single most, I want to use the word offensive or damaging piece of that bill that would impact the average Floridian? And then let's talk about how it would impact them so that they understand.
Well, the bill was filed just last week. It's actually going to be heard in the House Civil Justice Committee, I believe, on Friday. It's a 22-page bill, and in that 22 pages, it does a lot of harm to Floridians. Mm-hmm. What it does in a nutshell is it puts a lot of padlocks on courthouse doors all over the state. And it tells a lot of people around the state, doesn't matter how badly you've been hurt, you can't come into this courthouse and hold the wrongdoer accountable. Doesn't matter how much your family has suffered, you don't get to come to this courthouse and hold the wrongdoer accountable. If you want to, kind of look at what I would just call the lowlights of the bill, it does a number of things. But to answer your question, what is the single most troubling part of the bill? To me, it's the essential elimination of insurance company bad faith in Florida. Okay. So Florida law right now basically requires insurance companies to treat their insureds and to handle every claim in a fair and reasonable manner. Bad faith is the component of the law that holds insurance companies responsible when they don't act in good faith in resolving and adjusting claims appropriately. This bill, House Bill 837, essentially removes that. Among other things, it gives insurance companies a 60-day safe harbor. So if an insurance company acts in bad faith and fails to settle or adjust a claim reasonably, then the injured party has to give them 60 days written notice to cure the claim. If the insurance company cures it within 60 days, they're off the hook. Now imagine if we did that for criminals and said, all right, if somebody breaks into a store and steals a bunch of property, imagine if we were to say to the criminal, you know what, we're going to give you 60 days written notice to return the stolen property and say, I'm sorry. And if you do that, you're off the hook. We would never dream of doing that for criminal conduct. Why is the legislature proposing that we do that for other illegal, harmful conduct?
So let's talk about bad faith so the average viewer can understand it. Can you give us one or two examples of something that's easy bad faith in an auto accident case, let's say, where an insurance company acted in bad faith? Just a random scenario. It doesn't have to be a particular case you handled, but just any type of fact or situation so the average viewer can understand.
Sure. So I assume you own some cars. You've got a family. You own a couple of vehicles. Yeah. I assume you carry auto insurance on those vehicles. All right. So now let's say that you are driving home this afternoon and for one reason or another, you're not paying attention. You run through a red light and you cause a crash and you hurt several other people. Those other people, they're going to look to you and your insurance company to settle that claim, to pay their medical bills, to cover their lost wages, to pay their pain and suffering, those non-economic damages we talked about earlier. You want your insurance company to step in and handle those claims, deal with those claims, and to the greatest extent possible, pay those claims to settle them so that you and your family don't get sued and so that your financial assets and everything you and your family have worked so hard for are not put at risk.
Okay.
All right. Your insurance company is responsible for doing that and doing everything they can to protect you and your family from that exposure by settling those claims. If your insurance company doesn't do that, if they neglect reasonable opportunities to settle those claims, and you later get sued by them and get a big judgment against you, your insurance company is responsible for paying the full amount of the judgment if it is determined that the insurance company could and should have settled those claims when they had the opportunity and failed to. That's bad faith in a nutshell.
Okay.
It is the insurance company's unreasonable conduct that leaves you, their insured, at great financial exposure. Okay.
So for instance, in that scenario, lawyer is representing, let's say you're the lawyer representing the people that I injured in this case. Let's say I run a red light, have a moment of bad judgment, run a red light, it happens. I cause serious damages. You're representing these people. You send over a letter. Hey, listen, these people, they have serious injuries. One of them had to have a surgery on his neck. He's got an implant in his neck now for the rest of his life. And, we're asking that you pay X amount of dollars. Please get back to me in 30 days. And let's say they blow the 30 days and you follow up with another letter. You say, hey, I don't know if you got my letter, but here it is again. And this time, please confirm you got it because, I gave you 30 days. I'll give you another 30 days. And they still blow the letter. And then you send them a third letter and you tell them, listen, you got 15 days. And this time you confirm that they received it, right? That would be something along the lines of bad faith, where they had opportunities to settle this case and they don't even respond.
Right.
Right. Okay. So how does that play into this new law that they're wanting to pass, this new House bill? How does that affect the average consumer? Like, what would play out if they did this new bad faith change? What do you think would play out? Do you think that scenario would play out where insurance companies would just not even respond in a timely fashion to demands for, settlements?
I think that's highly likely. I mean, right now, even with the threat of bad faith hanging over every insurance company in every case, it is still very, very difficult to settle claims timely and fairly and reasonably. As I often tell people, look, if insurance companies always did the right thing, I'd be out of a job.
Right.
In every case I handle, it is my client that typically calls me because they've tried unsuccessfully to get the claim settled on their own with the insurance company. And when they are getting stonewalled, they pick up the phone and call me, and we step in, and then we end up basically in litigation against the insurance company. So with the passage of this law, if it were to pass, then what it does is, in your scenario, if you're sending letter after letter after letter and the insurance company is just ignoring those letters, then you file a document with the state of Florida that basically is a complaint form that says this insurance company is not responding to me. The insurance company will get a copy of that complaint, and they've then got 60 days to respond to you and try to settle the claim. As long as they do that within 60 days, it's a get out of jail free card.
Okay.
It excuses, no matter how bad their conduct was up to that point, as long as they fix it, once they're told, hey, you screwed up, then they're off the hook.
Yeah. Yeah. And, I love, you're talking about a civil remedy notice.
Right.
Right. So civil remedy notice, it's a website. You go to it. You can, any Floridian can create an account and file a civil remedy notice. And a lot of people do, and they get nowhere. And even as a lawyer, I file them all the time, a civil remedy notice. And the response is usually maybe hey, they pick up the phone. Hey, let's settle this case real quick. What most often happens is, and when they say, hey, let's settle this case real quick, it's like, hey, you caught me. Let's settle this case. I don't want my boss finding out about it. I don't want to get in trouble. But what often happens, most often happens, is the insurance company responds with not the facts. Hey, we messed up. We're sorry. It's your civil remedy notice, your complaint is invalid, and here's why. And they list 30 different reasons why it's invalid, and it's the same 30 reasons that on every letter that they respond to. It's never specific to my complaint. It's just a generic response, and it's almost like they don't care about bad faith in those scenarios. They don't care, and passing this new House Bill 837 freaks me out because I know it'll get worse.
Absolutely.
Yeah.
I mean, bad faith is the one thing. It's basically insurance company malpractice, right? As lawyers, if we mess up and cause our clients harm, we're responsible for legal malpractice. If a doctor messes up causing his or her patient harm, they're responsible for medical malpractice. Right now, if an insurance company messes up causing their insured harm, which is often horrendous financial exposure, bad faith is essentially insurance company malpractice. This bill would essentially eliminate that. And imagine, if insurance companies, as tough as it is now to get them to pay claims timely and fairly, because they're great at deny, delay, defend, right? They'll drag it out, lowball you, delay things as much as possible, hoping that you and your client get so fed up that you just say, fine, we're going to walk away from this. And it happens. If you remove, and that's even now with the incentive to settle. If you remove that bad faith incentive and basically say, no matter how much you deny and delay the claims, as long as you fix it once you're told you've been caught, you're off the hook. Okay, I think it's a recipe for disaster because the number of insurance claims denied will skyrocket. The delay will be even worse. You'll have more lawsuits being filed because a lot fewer are going to be settled in the early stages.
Right.
Yeah.
Right. Let's talk about another. We talked about bad faith. I think the viewers get it. Let's talk about LOPs. There's basically the law doesn't say that the doctor can only collect whatever Medicare rates are for those procedures. It doesn't say that. It says you can only tell the jury this is how much money's owed. This is all that you're going to get, that you're going to be able to board at trial is whatever Medicare rates are, which is, they say 100% of Medicare, but that's the Medicare rates. So, in our own industry, right, in a lot of these doctors, some of them charge astronomical rates for surgery. They feel that their level of skill, expertise, background, training is justified by their bill. That's how they come up with their bill and justify it. Those doctors, no matter if they're the world's best surgeon in the entire planet, they're all going to get the same rate across the board, which to me sounds not the free market. It sounds like, hey, this is... So it almost goes back to death panels back in the day. Hey, listen, the government, if we go to socialized medicine, the government's going to tell you when you're going to die. At a certain point, it's not worth it to pay for your health care. And it sounds like that to me. Basically, if someone's practicing, if they're a doctor and they're in this industry and they're treating someone who's the victim of a car accident or injury case, they're only going to be able to They're going to be able to bill whatever they want, but once the case goes in front of a jury, they can the insurance company only has to pay Medicare rates. So we're going to be in a scenario where, let's say you go to trial, you do a fantastic job, the jury is only allowed to award. Tell me how that works. You go to trial on a case, you've got $100,000 bill, $100,000 in bills related to a surgery. It's a neck surgery, top of the line surgeon does the work. How does that work under this new law?
Well, let's just take an example. All right, let's just say Joe Smith is in a car accident, has bad injuries, ultimately gets to a doctor that he thinks is the best surgeon, one he trusts, and decides that that's the doctor that is going to take care of me. And let's say the doctor's total bills are $100,000. All right, under the current law, when the case goes to trial, we can tell the jury about all the treatment, about the doctor's qualifications, and they'll hear that the total medical bills were $100,000. Under this House Bill 837, the jury will never hear that the total bills were $100,000. They're going to hear some far lower amount, depending on whether Joe had health insurance or not.
Okay.
Depending on whether the doctor treated the patient under what's called a letter of protection. And a letter of protection goes by a number of different names, but it's basically just a promise to pay later. is really all it is. And it's something that, a lot of people use in all kinds of scenarios in everyday life. It's kind of an IOU. So let me back up and unwind it just a second. Every client that comes to me that's been in a horrible accident and suffered injuries, the first thing they say generally is, I want the best doctors because I want to get better. They never come in saying, hey, Eric, get my medical bills as high as you can make them. They never come in saying, hey, I am so happy I was in this bad wreck and have all these horrible injuries because now you're going to help me get rich. Never. It is, I'm miserable, I'm suffering, I'm out of work, my family's suffering, I can't pay the bills. They're worried not only about their financial future, but their medical future. Right?
Right.
And so when anybody is hurt, I think we all want this for ourselves and our families, you want the absolute best care, regardless of cost. All right, so the bill, you're right, it is the absolute opposite of free market. But let me take another example. So in Joe's situation, Joe gets hurt, Joe goes get medical treatment, and let's say Joe does not have health insurance. And Joe's not a rich man at all. And because of his injuries, he's now out of work. So as his lawyer, he comes to me, he says, Mr. Romano, I need treatment, but I don't have any money. And my doctor's telling me I need surgery. How do I pay for it? I tell Joe, well, look, you can reach an agreement with your doctor. This doctor will provide you all the treatment you need with your promise that you will pay him later on when your case is done. That's essentially the letter of protection, right? Under that scenario, this House Bill 837 says that the jury's never going to hear that the doctor's bills were $100,000. The jury will hear the Medicare reimbursement rate for those charges. And on $100,000 in bills, the Medicare reimbursement rate might be $12,000. Right? So the jury's going to hear that the total cost of his medical care was $12,000. Let's say the jury awards that at the end of trial. Now, here's what happened. Joe has his $12,000 to cover his medical bills, but Joe owes his doctor $100,000.
Because this new House Bill 837 doesn't say the doctor has to accept the Medicare rates.
Right.
It just says the jury doesn't hear what the actual bill is.
That's exactly right. So it limits how much Joe can recover for his medical bills, but it in no way limits the amount that the doctor can charge for the medical services. So now Joe has $12,000 to pay a $100,000 bill that was caused by the wrongdoer that ran the red light and crashed into him. So now, where's Joe going to come up with that $88,000 difference? He's either going to spend the rest of his life trying to make payments to the doctor, or he's going to end up in medical debt. I mean, the vast majority of bankruptcies in America are driven by medical debt. And that is what's likely to happen. Or to the extent Joe's going to need future medical care and can't afford it, he's going to end up on the state Medicaid rolls.
From this kind of a law change, what industry benefits? Who benefits in the long run? And obviously, the insurance companies would benefit from something like this. Does the consumer benefit really by lower car insurance rates? Because Florida has the highest insurance rates in the country, top 3, whatever, highest auto insurance rates in the country. We have literally the shittiest coverage I've ever seen. I used to practice up in Michigan. My ex-girlfriend, I told her I'll never practice in Michigan. She was from Michigan. Broke up with her. 2 years later, I'm practicing in Michigan. Don't ask me why. It's too cold. I stopped going. But Michigan had, at the time, they had unlimited PIP for the rest of your life. If you were in a car accident in Michigan and you were a quadriplegic, you would receive insurance checks for the rest of your life. You would receive the very best medical care that you could get anywhere in the country you could go to. And they would even retrofit your house. Let's say you're in a wheelchair now. They'll retrofit your house to make it wheelchair accessible. Your van, they'll give you a wheelchair accessible van. In Florida, we get $10,000 for property damage, $10,000 for PIP, and maybe $10,000 for bodily injury coverage. I was paying the same amount of auto insurance in Michigan that I was paying here in Florida for the totally vastly different. It's insurance, but it's not the same coverage, right? So Is there any data that shows these kind of laws actually lower premiums?
There is. And in fact, Florida had a wonderful opportunity 2 years ago to significantly reduce auto insurance premiums and the cost of car insurance for most every Floridian. As you know, because we've talked about this, the Florida Legislature overwhelmingly passed in a bipartisan way legislation that would have required every driver in the state to carry bodily injury liability insurance. We're the only state in the country that doesn't require either bodily injury liability or underinsured motorist coverage. This would have brought us in line with 49 other states. Wow. We're the sole holdout. So that legislation passed the Florida House and Senate with 92% bipartisan support, and then the governor vetoed it. That was a missed opportunity to bring auto insurance rates down for the vast majority of drivers in Florida. And because we have, stuck with the old, no need for car insurance in this state, which is still crazy to me, given the number of people here, the number of tourists here, the number of visitors here, the number of cars on the roads. There's a very high likelihood that if somebody crashes into you, high likelihood that that person does not have any insurance. And if they do, if you're lucky enough that they do, it's likely not enough to cover all of your damages or injuries.
It's minimum.
It's minimum. I mean, look, right now, Florida law requires every driver to have $10,000 in PIP, $10,000 in property damage, no coverage for bodily injury liability. So what it means is Florida right now, Florida law values property more than humans.
Wow.
So if you cause a crash, you're required to carry insurance to fix the car you hit. You're not required to carry insurance to fix the people you hurt.
Wow. That's well said. What I want to talk to you about now is we talked about PIP a little bit and the past legislative attempts to get rid of PIP. And I see that perspective with the way things are going right now. The governor has said he wants to lower auto insurance rates. That's his stated goal. This bill was not proposed by him. To our knowledge, it was presented by two people, one from Miami, one from Tampa area, Lakewood Ranches. Are there any legislative changes that you think may help reduce rates besides getting rid of PIP? Is there any? That's probably a tough question. Sorry, we could take a minute and we'll pause it. But is there any? I guess here's what I want to ask. The governor said he wants tort reform. He's got a super majority in the House and Senate right now. It seems very likely that something will pass. Is there? I guess my question is there anything that you could think of that would be acceptable?
If the bill added a provision that insurance companies are required to reduce premiums as a result of these changes, that would help.
Okay.
That's not the end-all solution, but that would help. So here's the deal. Every time the insurance industry has come to Tallahassee in the past and pushed for legislation like this, claiming we need this legislation to lower insurance premiums, the response from us is always, well, then why don't we just put something in the bill that requires you to lower insurance premiums? Because you're saying, if we pass this bill, premiums will go down. Well, put your money where your mouth is, and let's just put a provision in the bill that says, as part of this legislation, insurance companies, you're required to lower your premiums. They always resist and say, nah, never mind, we don't need the bill then. They resist that. And there's only one reason why. Because they know insurance premiums are not going to come down as a result of any of this legislation. All it's going to do is increase insurance company profits. Because the insurance model is what? Take in as much money as you can in premiums, pay out as little as you can in claims. That's why on the claims side, where you and I come in, it's deny, delay, defend, right? The more they can deny and delay, and the more they can take in premiums. In other words, less they pay out, more they take in premiums, it just increases that profit margin.
Yeah.
That's all this legislation's about, is to put more money in insurance company executive pockets.
Yeah, and you're missing an important part of the insurance business model, which drives me crazy, which is we're forced to purchase insurance because 100 years ago, insurance companies went to the legislature and said, hey, cars on the road, they're dangerous. Everyone should be forced to have insurance to compensate people when they're injured. That was the mindset behind insurance. And they said, yeah, makes sense. Let's do it. And by the way, you're giving me bags of cash as a legislator. I'll take it. So they passed this rule that you have to have auto insurance. And the bargain for auto insurance is when someone gets hurt, that they don't get sued, the insurance company makes payments. Now they're backing out of that other half of the deal. They're complaining that they're not making enough profits, and they're saying, give us more favorable laws, which this law doesn't help the consumer in any way. Under no circumstances have we talked about any Florida driver being helped in any way. The only way that it would help them is if rates went down, and they won't even agree to rates going down. It only helps insurance companies. This bill that was passed, that was presented, I should say, submitted. So this new proposed bill that was filed, it's not passed yet. It's not law. Right. What can we do as Floridians, as trial lawyers, as doctors who see and help people who were injured? What can we do?
Well, a number of things. I mean, first of all, it's our responsibility to educate the public about any legislation we see like this that strips away their rights, reduces access to the courthouse, and can adversely affect them. Because most people don't pay attention to things like this until they're in that situation and need a lawyer or need to file a claim. Right. So step one is educating our clients, educating professionals and others that we work with to the extent we can through our networks, get information out to educate people about what's in the bill and the harm that it would do. Second thing is contact our legislators, encourage our clients, family, friends, neighbors to contact their legislators and let them know this is a bad bill with bad provisions. It's going to hurt a lot of people and they should vote no on it.
Okay.
And third, to the extent that you or anybody watching has clients who have been in scenarios like we've talked about that would be adversely hurt by these provisions, those clients can tell their real stories to the legislators, have them call their legislators, or better yet, go to Tallahassee to either testify or meet with the legislators up there. Okay.
And they can go to Tallahassee. The session starts in March.
I forget the exact date, but it's coming up. It's a 60-day session, so it lasts about 2 months. And FJA, we talked about earlier, has an extraordinary team working on all of these issues. Clients can get in touch with the FJA staff, and they can kind of put them in touch, put them in the right places, and help them share their stories.
Okay. And organizations like FJA, I want to say here the silent protector in Tallahassee, protecting Floridians from stuff that, these guys, the average Florida person is working 1 to 2 jobs, putting food on the table for their family, paying bills. Rent's so high right now because all these out-of-staters coming here to Florida, and they're just dealing with day-to-day stuff. They're not fighting for themselves. They're not saying, hey, if I'm injured in a car accident and I can't work for 2 weeks or 2 months or a year, or maybe I have back pain the rest of my life, I want to get compensated fairly. They don't have time to fight that. And the problem is, once it's passed, right? We're not going to be able, it's going to be very hard to backtrack something like this kind of legislative change.
Right.
Yeah.
Well, and I can tell you this. I mean, you asked a question earlier about, what does FJ do to protect the public? The reality is, anybody who has ever been injured in Florida and needed to file a claim, whether it's an insurance claim, a workers' comp claim, a disability claim, or ultimately a lawsuit, has FJA to thank for their ability to do that. So if Joe Smith was hurt in a crash and filed a claim and recovered compensation through the help of an attorney in the civil justice system, that's because of the FJA work the work that FJA has done for decades in Tallahassee. And it's every single year, it's the insurance industry and corporate America, basically, that is coming to Tallahassee to chip away at those rights, because they know if they can be held accountable for their wrongdoing, it's bad news for them. Wouldn't it be nice to get up and go to work every day knowing no matter how bad a job you do, there's no accountability? Mm-hmm. I mean, that's what the corporate and insurance industry try to do with legislation like this, is to go and say, we don't want to be held accountable when we do wrong. Mm-hmm. And that in itself is wrong.
All right. So I wanted to ask you if, one of the stated changes of this tort reform, which we know is deform, it's not good. One of the stated changes is to reduce litigation, right? There's going to be an incredible amount of litigation on all of these new issues, right? What is a letter of protection? CompNeg, comparative negligence, right? There's a proposed 50%. If you're 50% or more responsible for this accident, you get nothing. You get zero. There's going to be a ton of litigation on those cases, right?
Right.
And on top of that, you mentioned that because they're trying to strip down bad faith, there's going to be even more litigation because the insurance company has very little incentive to settle pre-suit before a lawsuit's filed. So we're going to see a wave of litigation, which is the opposite intention of this bill, stated intention. We don't know the real. We know the real intention is to benefit insurance companies, but the stated intention is to reduce litigation. You agree with that?
Absolutely. I mean, look, I think most good lawyers, try to settle claims with the insurance companies first before filing a lawsuit and getting into litigation. Mm-hmm. If you eliminate bad faith, as this bill would do, there's no incentive anymore for the insurance companies to settle those claims. I think most lawyers, what they'll do, they'll still take those claims because you still have clients to represent who have been harmed, mm-hmm. right? But instead of trying to settle the claim early with the insurance company, you're going to skip that process because it'll be an absolute waste of time and resources. You'll just file suit immediately. Mm-hmm. So I think you'll see an immediate spike, maybe not immediate, but a very quick spike mm-hmm. in the number of lawsuits filed, because there will be no reason for an injured claimant and their lawyer to even try to settle with the insurance company early on. Mm-hmm. All that's going to do is delay things. So the other point you mentioned with regard to some of the provisions regarding comparative fault, the limitations on the medical damages that could be recovered. You'll have many trials within a trial mm-hmm. fighting over those issues. So what in the past might have been a 4-day trial now could turn into a 2-week trial because mm-hmm. you've got to spend days litigating medical bills and Medicare reimbursement rates and other details like that, bringing in all kinds of additional experts, which drives up cost. Mm-hmm. So you'll have longer litigation, more expensive litigation. That's bad for everybody. And what's the end result of that ultimately? Drives insurance rates up. Mm-hmm. So it has the opposite effect of what the insurance industry is claiming it will do.
Yeah. And I mean, I would love to be at a round table where I could sit and talk with these people and say, hey, listen, this bill you're proposing is trash. It's not going to help solve any problems. Maybe here's some proposed solutions. Everybody wants to get the frivolous lawsuit, the outliers, the fraudsters. And then they want to categorize that small sliver of what we do, and they want to span it out over the entire industry. There's so much frivolous litigation. There's so much fraud. No, there's very little bit of that. It's in any industry, right? The insurance companies. I mean, United Auto. To me, that's a criminal organization. How they operate their business. There's a lot of lawyers that will not take bodily injury claims against United Auto because they usually only sell a 1020 policy. They only $10,000 max per person. And their initial offer is $500, and that's their final offer. You can't get the adjuster on the phone many times after that. And nobody's saying, hey, nobody in the legislature is saying, hey, let's go after these insurance companies that collect premiums and then are nowhere to be found, don't answer their phones. United Auto for a while wouldn't hire people who spoke English to create a barrier.
This bill, like so many that focus on the civil justice system, tries to fix a problem that doesn't exist. All right. So put it in perspective. The number of personal injury lawsuits filed in Florida courts, it's less than 1% of all cases filed annually.
That's in Florida?
That's in Florida.
Wow. That's an amazing statistic.
I've seen similar statistics nationally, but that's fairly typical. number of personal injury lawsuits filed, less than 1% of all cases in our court system. Something like 20 or 30% are business lawsuits. It's businesses suing other businesses, businesses suing their customers for payment.
Right.
But you're talking about a small sliver of the actual cases in the court system. And you get a massive piece of legislation like this to fundamentally overhaul decades of Florida law, fixing a non-existent problem, for a segment that is just a small sliver of what's in the court system right now.
Wow, that's an amazing statistic. Okay. So, all right, question for you. Anyone in the world, any place in time, who would you have a cup of coffee with and why?
I think I would love to have a cup of coffee with John F. Kennedy. I look today at how divided our politics are. Now, he died before I was born, but I've always had great admiration for him as a leader, as somebody who truly tried to unify diverse interests. He went through a very unique time in leading the country, dealt with some extraordinarily difficult challenges, just with the Cold War, with the Cuban Missile Crisis. I've read a lot of books about his approach to leadership and governing, and I think our elected leaders, frankly, and fellow citizens today could learn a lot from his example. And awesome. I'd love to be better educated by him over a cup of coffee if I could.
Yeah. How can people get a hold of you if they are interested in talking to you, hiring you, just consulting with you about any matter? How can they get a hold of you?
Best way to get a hold of me is send me an email, eric@romanologroup.com, and that's Eric, E-R-I-C, Romano, R-O-M-A-N-O. I'm right here in West Palm Beach.
Cool. Awesome. Thanks. And thanks for being on the podcast. Really appreciate you coming out here today.
Hey, thanks
to
for having me.
Educate our viewers. Thank you. Appreciate you.
All right.